introduce the Chief Justice briefly. She is the first woman Chief Justice in Canada. She graduated from the University of Alberta, getting a bachelor degree in philosophy and master degree in philosophy and LLB. She passed the Alberta Bar and also British Columbia Bar. She also worked for the University of British Columbia as a tenured associate professor for 7 years. Her judicial career began in 1981 at the Vancouver County Court. And then she became a justice of the Supreme Court of Canada. And she was appointed Chief Justice of Canada in 2000. The Chief Justice also published numerous articles and publications. And especially, we appreciate our husband, Frank McArthur, accompanying her, and he's also a lawyer in Canada. Now, she will give a speech on gender equality, the Canadian experience. Please welcome the Chief Justice McLachlin with applause.
Today, I will speak, as you know, a little bit about the Canadian experience in gender equality. Where we were, where we are, and where I hope we may be in the future, your future. It is my story from my country. You have your own story from your country, of which this university is part. And although I am unable to speak about your experience, I hope that aspects of the Canadian story of how women have advanced will resonate with your own stories and make you think about your own place and the place of women in your society. The history of women's place in Canada is a history of a long struggle to achieve legal equality. Today we stand at a place where, as I will tell you, our Charter of Rights and Freedoms forbids any laws that discriminate against women and guarantees fundamental rights and freedoms equally to both men and women. At law, women are equal to men. They are entitled to equal opportunity, benefits, and, of course, burdens. But it was not always so. The law, until relatively recent times, held women back. In Canada, as possibly here, I do not know, a century ago, women could not hold property. Women could not vote. Women were, in effect, although respected, treated as quasi-chattels. Until marriage, they were under the control or dominion of their father, and after marriage, basically they became subject to their husbands. The law in our country even denied them an interest in children who were technically regarded as the property of the father, who was the head of the household. Despite these laws, women throughout history, and our history is no exception, have succeeded in achieving a measure of independence. But that measure was small. Denied legal protection, women historically have had little choice in what paths they pursued and what life choices they made. And then things began to change in the early 20th century. The focus became removal of the legal barriers that stood in women's way. And then it moved on to a focus on assuring full economic and social equality for women. Something we in Canada have a legal term for, which we call substantive equality. I like to think of the progress of women in my country as a journey on a road, the road to equality. It started with the quest for bare democratic rights, the right to vote. It went on to a fight to have equal opportunity to hold office and work. And finally, it is moving on to substantive equality, the right to enjoy equal importance, equal economic value to that of men. I'm going to talk about these three phases. Let me start with the first one, which is almost 100 years old now in our country, which is the right to vote. There's a quaint term in English for the right to vote, and it's called suffrage. I'm not quite sure why. I should have looked it up. But the rallying cry at the beginning of the 19th century became the cry for women's suffrage, women's right to vote. There were many who argued that women didn't need a right to vote because they were protected within the family, which was represented by the husband, the father, and therefore their vote was part of that family unit. Even progressive people made this argument. But strong and courageous women realized that unless they got the right to vote, they would not even be able to get to the first step of changing society in a way that would be better for women. Women knew they were working. Women have always worked hard. They were raising children, working on homes, in farms and factories, sometimes teaching, often side by side with men, sometimes on their own. And these women started asking, why should they not have a say in the running of their country and in democratic governance? And so the battle for the vote began. A few brave women in England, the United States, places like New Zealand and Canada began to campaign for legal equality and the right to vote. And it was a very hard campaign. Some were persecuted and thrown in prison. Some were force-fed. They starved in protest, and they were force-fed in brutal ways. Some died. But gradually their story got out, their dream got out, and it spread. I had lunch today with a justice who said this. I don't know if it's a Korean saying, but he said, one person's dream is an idea. Many persons' dream is a reality. And that is what happened with the idea that women should vote. So gradually, women did get the right to vote. Australia, Norway, Estonia, United States, United Kingdom, one by one, these countries granted women the right to vote. In Canada, we are celebrating the 100th anniversary of women's suffrage this year. We've come a long way. Long after our Constitution was adopted in 1867, the right to vote was still restricted to a privileged few men. And in Canada, as elsewhere, a few women over 50 years of sustained effort secured the right to vote. It's difficult to underestimate the transformational effect on Canadian society of granting women the right to vote. One of the most well-known Canadian women behind the suffragettes movement, as it was called, Nellie McClung, in presenting a petition to the Alberta legislature in 1915, calling for the right to vote, predicted that women's suffrage would cause a tidal wave of political and social change throughout Canada. And although the wave built slowly, in the end she was right. women's suffrage paved the way for the gradual elimination of all obstacles preventing citizens, every citizen, women, Indigenous people, persons with disabilities, religious minorities, inmates from voting, and therefore participating in a civil society. The first battle was the bare right to vote, but other battles lay ahead. Winning the right to vote represented a key step toward equality, but it did not bring equality. Women could vote, the law now said, but in Canada at least little else had changed. Women were told in particular that they could not hold public office. What did that mean? They couldn't serve as a judge, they couldn't serve as a politician, they couldn't serve in the Senate, they could not hold any public function. This was because the British law, which Canada had adopted and was under at that time, said that only persons, P-E-R-S-O-N-S, quote, end quote, could hold public office. And this was a relic of very early days, but it was considered to have constitutional force. So courts ruled, ruling after ruling, that women could not hold public office because everybody knew women were not persons. Well, there were some women in the west part of my country, in Alberta, who decided to challenge that. And they had to, it was a long and hard road in that challenge. They had to raise money. They won at the first court, but then they got defeated. The Supreme Court of Canada said, no, the law is quite clear. Women are not persons. Go away. But they didn't take that for an answer. They went out and raised more money. At that time, the final court of appeal for Canada was the Judicial Committee of the Privy Council, which sat in London, England. And so they raised their money, they hired their lawyers, they took everyone over to London and they argued their case. No one thought they had a hope of success. But in the end, they convinced the judges on the Judicial Committee of the Privy Council that the time had come to recognize that women had a larger role to play in society, that women were indeed persons. And the Privy Council so ruled. And in so doing, Viscount Sankey said, the constitution of a country is a living tree. It bears new branches. It bears new fruit as times change. And we must recognize that. And that metaphor of the Constitution as a living tree is one which still guides our constitutional jurisprudence in Canada. How was the decision of the Privy Council met? I took the trouble to look up some old newspaper archives, and I was shocked to find that newspaper editorials across the country denounced the decision. They predicted that it would undermine morality and fundamentally change Canadian society. Well, they were certainly right about the second part. The person's case proved a pivotal moment for Canada and ultimately its constitutional values. One by one, the barriers to gender equality were being removed. First the vote, now the denial of the right to hold public office the right to hold public office had been affirmed. Let me tell you a story about 10 years later. 1939, a decade after the Judicial Committee's decision in the Persons case, King George VI and his consort, Queen Elizabeth, were visiting Canada. While in Ottawa, the nation's capital, one of their tasks was to lay the cornerstone of the Supreme Court of Canada building where I work. Normally, this was a task that the king would perform. However, on this occasion, the Queen stepped in and performed the ceremony. If you visit the Supreme Court, and I hope some of you will someday, you can see a grainy photo of the event. The Queen said this as she at the ceremony, and I quote, "Perhaps it is not inappropriate that this task should be performed by a woman," that is laying the cornerstone, "for woman's position in civil society has depended on the growth of the law." That is so true. I like to think that when the Queen said those words, she was perhaps thinking of the Persons case that had come from Canada 10 years earlier. The Persons case opened new doors for women in Canada, but the quest for equality was far from over, which brings me to the third portion of the road we have trod in search of equality for women in my country. Formal legal equality had been achieved by the right to vote, by the right to hold public office, as well as by a growing number of human rights and other laws that proclaimed that all human beings were equal, regardless of gender and other personal characteristics. The law proclaimed equality. The problem was, and this came as a surprise to many people who had fought hard for equality, that even as society entered the last half of the 20th century, deep inequality persisted. Women still, for practical and cultural and social and other reasons, were unable to pursue the education or the careers that they might have wished to. Women still were confined to lifetime earnings much, much smaller than those their male counterparts could expect. And people began asking the question, we thought the end of the road had come, that we had won equality, but why have we not got real equality on the ground? What do I mean when I talk about real equality, substantive equality? It means to us in Canada looking not only at the letter of the law, what the law says, but what the impact is. What is the effect, the impact? Because beautiful rights written in beautiful books are only part of the story of equality, we came to realize. We have to actually ask ourselves how laws, how conditions, how social strictures are preventing women from moving to fully equal partnership in society. And that is what we mean by substantive equality. Not mere formal equality on the books, but real equality that looks at the impact of measures that the government may take, the impact of social strictures, the impact of historic discrimination or historic cultural modes, and asks how can we, without jettisoning all that, mold them in a way that produces greater equality. This move to substantive equality began in earnest in 1982 with the adoption of the Canadian Charter of Rights and Freedoms. I will return to the Charter in a moment, but let me backtrack to explain in a little more detail why Canadians felt that it was necessary to adopt a Bill of Rights and put it in its constitution, in constitutional unchanging form, and include in that Bill of Rights equality. The modern human rights movement in Canada and around the world sprang from the ashes of the Second World War. In response to atrocities of the Holocaust and the harm caused by totalitarian regimes, conquest, capture, and you in this part of the world know some of that, early proponents of human rights advocated creating domestic and international laws to recognize and protect the inherent dignity of the human person that lies at the heart of real substantive equality. Internationally, the United Nations adopted the Universal Declaration of Human Rights in 1948. Canada's first Bill of Rights was enacted by Saskatchewan in 1947, and a suite of other Bills of Rights followed in all the provinces, culminating in the Canadian Bill of Rights in 1960. Now, the reach of these bills, and in particular the Canadian Bill of Rights on paper, was large. They protected the fundamental freedoms like religion, speech, assembly, association, as well as legal rights. And they guaranteed equality before the law. But despite this apparent broad reach, the Canadian Bill of Rights, which was adopted in the 50s, turned out to be a disappointment for many, including women. In fact, in the 22 years between its enactment and the adoption of the Charter, in only one case did the Supreme Court of Canada strike down a law for breach of the Bill of Rights. There were many reasons for this sad performance. The bill applied only to the federal government and not the provinces, and Canada, as you may know, is a federation. Further, it was contained in ordinary legislation. It wasn't constitutional, and therefore the argument could be made that a law that proscribed its provisions, an unequal law, if it had been properly adopted, overrode the Bill of Rights. So Canadians realized that they must move toward a constitutionally enshrined Bill of Rights. Under the Bill of Rights of the 1950s, the non-constitutional Bill of Rights, the jurisprudence on equality was narrow and disappointing. The logic was the logic of the ancient Greeks who thought about equality. Treat likes like and unlikes unlike. That's equality. Well, what does that mean? That means as soon as you can point to a difference in a human being, you can say, oh, well, it's all right to treat that person differently because she is not like the other person. So what does that mean translated to gender? It means that you can treat women differently because obviously women are different. So the logic of equality means treating like alike, which pervaded the jurisprudence, was not helpful to advancing women on the road to equality. I won't take you through the cases. They are numerous and detailed. But let me just leave it at this, a couple of examples. The law said that it was fine, legal, constitutional, to deny pregnant women and new mothers unemployment insurance benefits when men who could not work because, for example, of an illness might receive those benefits. The resultant unequal treatment the courts said, didn't come from the law. It was caused by nature, by the fact that only women could have children. So women were denied these benefits, while a man who, from a functional point of view, might be unable to work because of illness, was entitled to receive them. We would now say that is the height of inequality. At the time, it was defended as equality. The Canadians began to realize that they would have to move to a constitutional Bill of Rights. And the result, as I have indicated, was the adoption in 1982 of our Charter of Rights and Freedoms, which constitutionally entrenched rights. Many people were pessimistic. They said the courts would not respond to this new document in any different way than they had responded to the statutory Bill of Rights of the 1950s. But they were wrong. The Supreme Court of Canada of that day, and I of course was not on it, took a broad and purposive and substantive approach to rights. And equality jurisprudence changed. Let me give you an example, and there are many, of how women were able to rely on the values of substantive equality to begin addressing economic equality that still prevailed in Canada and in Canadian workplaces. Around the time the Charter was enacted, it became obvious that what was women's work, these are occupations that were occupied mainly by women, like nursing or some areas of teaching, was not being paid equally well to man's work. Typical justifications were that men's work was harder or more dangerous, or that men were the principal breadwinners, or that women's work was secondary and incidental. Whatever the reason, the reality was increasingly evident. More often than not, women were being paid less than men. So the government set up a Royal Commission on Equality in Employment, which was chaired by my colleague, Justice Rosalie Abella. The Commission's report documented the society-wide systemic discrimination faced by disadvantaged groups. It stressed the need for proactive measures to address this discrimination that affected all aspects of the labor market experience, including the ability to get work, the conditions of work, the retention of work, and retirement conditions. As a remedy, the Royal Commission called for an ongoing employment equity planning process. To achieve equity in employment, workplaces would be required to aim for equal representation, equal occupational distribution, fair pay, and working conditions for all. The recommendations led to the enactment of the first Employment Equity Act of 1986. The Act promoted employment equity as a reflection of the Canadian value of fairness, while demonstrating that Canada was encouraging workforce participation of 4 designated groups: women, Aboriginal peoples, people with disabilities, and visible minorities. The stated purpose of the Act was, and still is, and I quote, "to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to the ability and in fulfillment of that, unrelated to their ability." The attention given to employment equity, made possible by the Charter, has in fact produced favorable results over the years. Recent data shows that the gender wage gap for Canada is in slow but steady decline. In the province of Ontario, for example, it stands at 26% for full-time, full-year workers, meaning that for every dollar earned by a male worker, a female worker will earn 74%, or 74 cents. I note that Korea is no stranger to the gender pay gap. A recent report of the OECD puts your gap at 38%, somewhat higher than Canada's. Additionally, a third of women hold precarious or temporary work positions, and only 8% have supervisory responsibilities. These figures can be viewed in two ways. On the one hand, they represent considerable advances over what the situation was before. We started from a point of about 38% disparity in Canada. But on the other hand, they are clearly not as good as they should be. We are still some distance from the goal of full equality in employment. I could offer examples, many other examples, of the slow and steady progress along the road to substantive equality. More and more women in Canada are entering careers that were previously unavailable to them and are taking an ever greater place in the workplace and in the economy. The same is true here in Korea. More than half the students graduating from Canadian law schools in Canada are women. I do not know the statistics, but I know many of the graduates from law schools here in Korea are women. Many of the women in Canada stand at the top of their classes and achievement. They article and join law firms in equal numbers as men. Generally, throughout the economy, 58% of all women in Canada over 15 had jobs in 2006, up from 42% in 1976. More women are working, and more women are working in better jobs. At the same time, marital norms have changed in Canada. The old law, where women stayed in the home for the most part, and men went out to work, was based on a patriarchal conception of the family. And we began to realize in Canada that equality would not change unless social assumptions and conditions also changed. What we have seen in Canada, along with women coming into the workforce and into higher areas of the workforce in greater numbers, are commensurate social changes. Some people say those changes are not coming fast enough, but they are indeed coming. In Canada now, many men, married men, assume equal or almost equal responsibility for parenting. The marriage is viewed by many young Canadians as an equal partnership where both will work outside the home and both will have equal responsibility for the children. Of course, that is not always the case. And of course, too often the default position is that it is the mother who stays home with the child when the child is sick, or the mother who makes the sacrifice to her career when things simply get too much. But we are slowly moving in the direction of a new family paradigm in Canada, where a paradigm of equal responsibility and equal sharing on all fronts. Let me conclude. I'd like to conclude my remarks with this by returning to the metaphor that I began with. The path to equality in Canada has been long and arduous. Yet we have traveled a good distance and covered much territory. Women can vote. women can hold public office, no matter how high, exalted, or important. Women can serve in the Parliament, the Senate, and the courts. Canada has a federal cabinet in which half the ministers are women. 3 of our provincial premiers are women. The Chief Justice is a woman, as you can see. A third of federally appointed judges in Canada are female. We have had a number of female governors general. That would be the equivalent of your president, although there are differences in power. It's largely symbolic in Canada. Huge advances. Not bad, you might say. When our Prime Minister recently was sworn in, was asked, are you sure you really want to have half women, half your cabinet women, and won't you be leaving out some talented men? He simply said, this is 2015. And the remark resonated because it told us it was time that Canada was represented not only by its many talented men, but also its women. Still, for all this progress, I have to admit that we have not come as far as I would wish. We have not yet reached the end of our road to equality. We have the right to vote, but more than a quarter women in Canada don't exercise it. We have the right to hold public office, but only 88 of the elected members of Parliament in Canada are women, out of a total of 338, or 26%. My study suggests that Korea is in an equally difficult situation, with only 16% of the seats in the National Assembly occupied by women. In Canada, women start and run small businesses more than men, yet the highest corporate positions in corporate boards are still dominated by men. And finally, women are more likely than men to experience discrimination, statistics tell us, and they are more often than men victims of sexual assault and other violent crimes. Looking at these statistics, we have to ask ourselves, notwithstanding all the great distance we have come, why have we not come further? Why are women underrepresented in law firms, in boardrooms, in the professions, in public office? Why are women, after all these years, still, in my country at least, not achieving equal pay for equal work? Why are they still experiencing violence in numbers disproportionate to men? And when we ask why, we are likely to find lingering hidden assumptions about the role and the value of women. Discussing these hidden assumptions, which I believe is the next step, will help to lead to an honest debate, to increase dialogue between women and men and women, dialogue that will bring new attitudes, new laws, and change to get us the distance we need to get. The cause for equality for women is an ancient one. The struggles of the past century and a half are just a small part of the story. Yet in that century and a half, we've traveled further on the road to women's equality than in any other epoch. With the removal of legal barriers to women's participation in civil society, and with the push to substantive equality spurred by documents like the Canadian Charter, women and men today have the tools they need to make change happen. Some say we have come to the end of the road. Some say we must accept that for all the advances made, women will never be quite as free, quite as important, or quite as well remunerated as men. I do not accept that view. I prefer to think that we have not come to the end of the road, but that, as the Irish would say, the road is rising up to meet us. There is a way to go, but with the spirit and courage and conviction of those who have traveled before us, I am confident that we can achieve it. Thank you very much.
And we will have a question and response session. So if you have a question, raise your hand and introduce yourself very briefly with your name and affiliation.
Okay, you, and then you. No, not at all.
Thank you very much, Madam, for having graced us with your presence this afternoon, and thank you very much for the talk. My name is Yoona Kim, and I'm a first-year law student. It's been only a few days since we started our first day of school. I have a two-part question, actually. You've introduced to us the concept of substantive equality, and I want to know the status in terms of substantive equality in North America. To reiterate my point, are the merits of female lawyers, judges, and justices appreciated by our male counterparts in North America or by the general public? That's my first question. And my second question is on a more personal level. You've mentioned that in Canada there is a new family paradigm where married couples practice, you said, equal partnership. And I was just wondering how equal partnership has been practiced in your family paradigm. You mentioned that you're very equal. I was just wondering, maybe your husband could answer this question.
He's already done that. Well, the first question, if I understand it, is are women who are practicing law or carrying on in the professions in North America, in Canada, do they really have the equal respect or the full respect of their male counterparts and of the public, if I can add that to your question, because that's what's really important. You go out there, you practice law, you have to have the confidence and the respect of the public if you're going to be a success. And the answer, I think I have to say honestly, is yes. There is absolutely no reason, one doesn't ever hear people say, well, I wouldn't want to go to that lawyer because she's a woman. Women lawyers are up front, right in the center. They are in our court all the time. They are in the leading courts. They are achieving great things, and they are sought after and respected, and they are playing a role in all the firms. So everybody wants these wonderful, bright women lawyers. What happens, though, has happened in the past, is that there's a high attrition rate, a higher attrition rate for women in practicing law than men. And it's not because people don't respect them or want them to continue to work and so on. I think the main factor, honestly, personally, is family pressures. Despite the changes I said were being made, I think that it often becomes very difficult because the law firm culture in Canada and in North America generally, I don't know how it is in Korea, is a very demanding one sometimes, and one has to put in long hours, and it can be very demanding and stressful. So sometimes if both parents are in such a job and they have children, they just make a decision that one of them, for a time anyway, will step back to a less stressful position, or in some cases even take a few years off. And then this has been documented in many books and studies. Once a woman leaves the workforce, she may come back, but for whatever reason, and again, it's not very logical, it's hard for that woman to come back at the same level. She tends to come back at a somewhat lower level and then have to work harder. So in terms of lifetime achievement, she sometimes is behind. So what we're having to tackle now, I think, are these systemic barriers. We need to tackle the culture in our workplaces. We need to realize that that culture was made possible by, as I said, an Edwardian society where mother was at home looking after everything on the home front, and father was out, and so of course he could work 12 hours a day because everything else was looked after. But that's not the way Canadian society works now. I can't speak for yours, but I don't think it's the case here either. People who are in the workplace can't rely on somebody else who's in the home taking care of the children and all of the other things. So the model, the social model that we've inherited doesn't fit with the work model, because the work model has stayed the same. The social model we have now doesn't fit with the work model. The work model has stayed like an Edwardian father. You got to be here all the time, work all the time. If we need you, we need you, and you're here, you know, however, pull an all-nighter if you have to, as we say in North America. But so we still have that old-fashioned work model, but we have different kinds of families. We have different we now expect women to be working, so it doesn't fit very well. So we have to work on changing that. And you know, I'm starting to see a lot of change. I'm starting to see a lot more understanding amongst lawyers, senior lawyers, law firms, and that kind of thing, that if they want to keep these bright, smart women, going back to what you said, they're going to have to make some changes. They're going to have to make some allowances. And you know what's happening in Canada is that the men are starting too, the fathers. They're saying, look, I want to be home with my child. And sometimes they're opting for alternative lifestyles. So all of these things take time, but that's the rest of the road we have to go.
Do we have to give a chance to speak?
Equal opportunity.
The second. I must say that I'm a very lucky individual because of the Chief's attitude towards work and society. And I guess maybe I was one of the lucky ones growing up. I had a mother who was sort of advanced in her time, and there was jobs to be done, and there were no jobs solely for women and solely for men. There was work to be done, and whoever was capable of doing it did it. And that's carried on throughout my whole life. And I've tried to do the same thing with our children, that the idea is, you know, it's not that the boys are working and the women are at home. Both of them are working, and their children are being brought up with the same attitude. If the men don't have the attitude of equality, then it's going to be a difficult task. And as many men, and there aren't that many in the room, could understand that, I think it would be a much faster change in society, that there would be equality all the way down the line. And I want to say thank you for the reception you've given the Chief Justice. And I just go along for the ride.
So, if you get
Yeah.
one more question,
Okay.
so who first? You.
Okay, thank you for the insightful lecture. My name is Youngji Kim, and I'm also in first year in the UL School. I was wondering, since there are a lot of advances, including decreasing wage gap, what are the current legal measures against the lingering gender inequality in Canada, other than just social changes? And also, moreover, I was wondering, what are your suggestions to improve the situation regarding this issue?
Mm-hmm. I'm not sure that there's a huge amount to be done in terms of just laws treating women as equal, because our laws are now more or less pretty good on that respect in Canada. One of the things we can do, though, is look for the unintended impact of certain laws and certain social measures. And that is where a lot of scholars are now focusing their attention. For example, a tax law that provides a deduction for childcare might have quite a strong effect in getting women into the workplace. Now, that law doesn't say anything about gender equality on the face, but you have to look not at what the law says, but at what its impacts are. So I think one of the things that I hope is happening in Canada is that when people are drafting new laws, especially laws in the social sector, that they look at those consequences. Or maybe they look at the tax law and say, that's a powerful way to help promote substantive equality. You can do a lot, for example, through tax law without ever mentioning the word equality. Just how you structure your family benefits. And every society does this. And we're playing around with that in Canada too. And different people have different ideas. But I think it's a chance to be quite creative in structuring benefit systems that foster women's equality in a substantive way, a real way. And that's what I mean by substantive. So I think that's an area where we can do more work. Another subject that's often brought up in Canada is better daycare, subsidized daycare. We have daycare, but only one province has what I regard as a really good system, which is a cheap system. Daycare can be very expensive in many places. But in the province of Quebec, I don't know what the price is now. It used to be $7.50 a day. I mean, just a couple of cups of coffee. A really small sum of money for your child to be cared for. And that is expensive a little bit, but it has many benefits. You also put a lot of money in the economy because there's a lot of childcare workers who are trained because it's all supervised and they're working, and I don't know the studies, but some people say it's a very, very beneficial thing for equality all the way around. Some people are lowering the rate, the time when, and we have done this in the past, when little ones start to school, that kind of thing. And what I already mentioned in terms of how we go the rest of the road, I think we have to continue to change attitudes. And I think we have a terrific opportunity with the millennials. My husband said you have to change the attitudes of the men, and he's absolutely right. Everybody's attitudes have to change. And as long as it's men versus women and that kind of thing, we're never going to get where we need to get. We have to get to a point where everybody accepts that it's going to be, that equality is going to be good for society and good for everyone. And when we get there, I think we'll have the job done. Thank you for that question. Excellent.
Do you mind answering the one more question?
No, I don't.
So this might be the last question from the floor.
Thank you very much for the last minute. Just wants to.
I'll try to keep the answer shorter.
So thank you very much for the thoughtful and insightful speech. And it's very encouraging for me to know how Canadians try to improve gender equality situation. But because you're not only a woman but also a Chief Justice, I want to reach out to a sort of philosophical question, because in face of the recent victory of AlphaGo against Korean Go champion, I feel very, very have to confess that I feel very threatening against the artificial intelligence, because I somehow feel that the only traits that distinguishes men or human from animal or any other thing is the ability to make decisions and judgments. But from the case of AlphaGo, it shows quite a prospect that artificial intelligence can actually make judgments and decisions, and sometimes it can be better than human beings. So, do you think those AIs could someday replace the legal profession? Because I'm only beginning my legal profession now, and if I can change my career path, I want to make quick decisions. That's why I'm asking this question.
Well, I don't know the competition you're referring to, but I have read a little about the emerging discipline or science or discussion going on about whether we're on the verge of creating mechanical intelligence that will be able to make its own decisions and ultimately outsmart us and outthink us and outdecide us. I've decided that being of a certain age, I'm going to put that one on the shelf for the younger generation. As long as in my lifetime they don't bring robots on the Supreme Court of Canada. I think I'm secure in my day job. But look, I don't know how to answer your question. It may be that at some point we'll be able to find machines to do things better than we, but something in me says I rather doubt that human intelligence, that human caring, that human values, which are what drive our society and everything good in it, can ever be replicated. That's not law, that's not science, that's just me talking. But I would say, and I'll close on this, one of the most important things you have going forward as lawyers is to develop a sense of ethics and values and caring and purpose. And those are not things that we look for or I think can expect out of machines. So good luck. Thank you.